Welcome to A Closer Look. I'd like to welcome my two guests today, but also you as viewers. Today, we'd like to talk about universal jurisdiction. And we're doing this because one of our CAS colleagues in New York, Mónica, has published a study on the universal jurisdiction. She named it The Road to Koblenz. So a warm welcome to you, Mónica Castillejos-Aragón. I hope I said that correctly. And I forgot the doctor, of course, and Professor Dr. Klaus Kress. Thank you both for joining us today. I know this survey, the study you did, Mónica, was a lot of work. And I know that you had an interview with Professor Klaus Kress while kind of preparing it. And in his foreword, he speaks very highly of the study. And I'm glad that both of you have found time to speak about the topic of universal jurisdiction today. Mónica, why did you write this study? Why do you think it's a very timely and important topic to speak about now?
Well, first of all, Philip, thank you so much for bringing us all together to discuss this relevant topic. And especially to discuss the outcome of the content of this report that the Konrad Adenauer Foundation in our New York City office published this year in order to discuss the relevant role that Germany is playing in the exercise of universal jurisdiction in the country. But also it's a pleasure to have this conversation with you and of course with Professor Klaus Kress, whom I deeply intellectually respect and admire for his work and contribution, not only in this topic, but in different areas of international law. And as you mentioned, there is no better time for us to have this conversation, because in January this year, it marked the second anniversary of the Koblenz decisions. But also this conversation is relevant because it coincides with an important legislative reform recently adopted by the German Bundestag related to the Code of Crimes Against International Law, which basically the members of parliament embrace and also assume the responsibility to expand the scope of the legal framework that regulates the exercise of universal jurisdiction in Germany. And over the past year, as you mentioned, I collected extensive expert opinions and perspectives, and it was a fascinating project because it allowed me to present in this report the often overlooked human component of the prosecution of international crimes and of the judicial decision-making process. And what was my motivation in writing this study? Well, you might agree that as legal experts, we have traditionally concentrated in the study of judicial opinions for us to understand, for example, the impact of nature of important decisions issued by different tribunals around the world. But perhaps from a theoretical perspective, when as legal experts, we analyze the domestic judicial politics, we often also ask ourselves, who gets what, when, and why. And I do consider like judicial opinions are relevant in order to analyze or understand the impact of landmark decisions as the Koblenz cases. But also I do believe that if we analyze the process prior to rendering judicial opinions, we are also going to be able to better understand the conditions and the important consequences of those judicial opinions. And that's why in this report, I'm basically highlighting specifically that the process is as valuable as any judicial decisions rendered by the higher regional courts in Germany. And perhaps that was my main motivation and the main contribution of this report in the debate of the exercise of universal jurisdiction, not only in Germany, but also in other jurisdictions that are actively engaging in the fight against impunity and injustice in different parts of the world.
Now, thank you for that. You've mentioned universal jurisdiction now more than once. It's actually quite a complicated concept, but it's the main concept of the study and is sort of the change, is sort of the news. And if you're watching this on YouTube, we'll link to the study below. But I'd like to ask you, Klaus, universal jurisdiction. I mean, what does that mean? Can you sort of explain to us what universal jurisdiction means?
I'm very happy to try to do this, Philip. Let me also, first of all, say many thanks for being part of this conversation, and also, with your indulgence, just one word of praise to Mónica for his work. This is really a fabulous study, and it is fabulous most importantly because it is not other than what you would expect with respect to a legal topic. It is not dry at all. It is fascinating, light, and even thrilling reading. And the main reason for this is that Mónica is not just describing black letter law, but she makes the law speak through the voice of the actors. And by this, she manages to give a fascinating account of almost 20, or a little even more than 20 years of legal history, contemporaneous legal history in Germany. So that should be said at the beginning. But now to your point, Philip, and of course that's key to understand the entire, the core of this study, the concept of universal jurisdiction and the exercise of universal jurisdiction. If you think of the exercise of national criminal jurisdiction in normal cases, you will expect that the state concerned pursues a certain national interest in exercising this jurisdiction. And this national interest is translated into what we lawyers call connection points. Somehow the set of facts which underlies the proceedings is connected with the domestic jurisdiction in place. So if Germany exercises jurisdiction over an alleged crime, it's either because the alleged conduct, the conduct alleged to constitute criminal conduct has taken place in Germany. That's the famous principle of territorial jurisdiction. Or to mention just one other important connection factors, there are others, is that the alleged offender is the national of Germany, in my example. So that's the traditional principle of active personality. So here you see, in the normal situation, there is some kind of link with domestic jurisdiction. And this is where universal jurisdiction fundamentally differs, because universal jurisdiction properly conceived, and I now leave aside all the nuances that one could think of, properly conceived, the idea is that the exercise of universal jurisdiction does not require any particular link of the facts, the relevant facts of the case, with the domestic jurisdiction concerned. And that already conveys the underlying idea. The underlying idea is, whenever a state exercises universal jurisdiction, this state is not primarily pursuing a national interest. Germany is not looking mainly, chiefly after German interests when exercising universal jurisdiction, but, and now a very important concept comes into place, it is the interest or the interests of the international community as a whole which is at stake. And this interest, these interests of the international community as a whole are concerned when the crimes at issue have a certain peculiar character, when those crimes are crimes directly criminalized under the international legal order. The crimes concerned are very few in numbers, but they are egregious, and the titles of those crimes, I'm not going into details now, are well known from public coverage. The 4 crimes or categories of crimes are the following, and they have essentially been stable since the beginning of the legal history of international criminal law. War crimes, crimes against humanity, genocide, and then the crime of aggression, the crime of unleashing a war of aggression. In those cases, the international community, or let's put it differently, states have agreed that whenever those crimes are committed, not just one single state, that the international community as a whole is concerned, and the consequence is that states acting as fiduciaries of this international community can take the matter up and commence criminal proceedings.
I have one question in this regard before I ask Monica about sort of how German courts have exercised this, and then also to ask about the main decision that is sort of central to this study. Everything that you've shared now with us, Klaus, doesn't it sort of incorporate also at least this is how I feel, an overstepping of sovereignty of possibly other countries? I mean, if Germany says we're going to apply universal jurisdiction, and we have a Bolivian, I'm just randomly picking a country, that has committed a severe international crime in Moldova, now Germany wants to apply jurisdiction. Wouldn't these two countries feel as though one is interfering in their sovereignty? How does that go along?
It's very understandable that you ask this question, because those traditional connection points that I mentioned at the beginning, territoriality, active nationality, they precisely serve the goal that you have now referred to, that states, whenever they exercise their criminal jurisdiction, do not, as international lawyers say, interfere into the protected realm, sovereign realm of other states. But here, the very fact that I mentioned a moment ago, that the interests at stake when crimes under international law are committed, that those interests transcend the national realm, the domestic realm, the sovereign realm. This makes the crucial difference. So the very notion of a crime under international law, the very notion conveys the idea, whenever such a crime is committed, whatever the nationality of the alleged offender, whatever the place where the crime is committed, it is the international community as a whole that is concerned and which, so to speak, takes a legal interest in that this crime doesn't go unpunished. And for that reason, as a corollary, logical corollary, no state can claim this is a matter that enters exclusively in my jurisdiction. This is simply not a notion that goes well with the idea of criminality under international law.
Now, Monica, you named the study The Road to Koblenz. Now, anyone that isn't German will surely ask, what is Koblenz? So first of all, I think we have to say it's a German city which has a higher regional court, and this higher regional court has, decided a very important case. And I'd like to ask you about this case. Why did you name your study The Road to Koblenz? What made this case so special, and kind of leading up to it, how is this case possible?
Well, first of all, Philip, I think it would be important to give you a little bit of background about this case. In January 2022, the world welcomed one of the latest Koblenz decisions issued by the Higher Regional Court. And in October 2019, the federal public prosecutor charged 2 men with crimes against humanity, who also happened to be former officials of President Bashar al-Assad's regime security apparatus. And in February 2021, and after 108 days of trial, the Higher Regional Court in Koblenz found that acts of murder, torture, and sexual violence had been committed at Syria's al-Khatib's detention center unit. And once the Higher Regional Court issued this landmark decision, both German legal scholars and other legal experts around the world not only celebrated this decision as the first domestic effort from Germany to bring justice to the victims of mass atrocities committed by the Assad's regime, but also it was important because it brought important legislative momentum for a responsibility that the German Bundestag embraced in order to expand in the following years the scope of the exercise of universal jurisdiction in Germany. And perhaps you're asking me why I named the study The Road to Koblenz. And this report also begins with an important conceptual question in terms of what accounts for such prosecutorial and judicial assertiveness in the exercise of universal jurisdiction, not only by the Koblenz Higher Regional Courts, but from other higher regional courts across the country. And this question basically was inspired by a compelling Washington Post article published back in March 2021, which it was titled, "Why Germany is Becoming a Go-To Destination for Trials on the World's Crimes." And the article poses two relevant questions. First of all, why Germany and under what conditions the Higher Regional Court in Koblenz was able to issue this landmark decision. But the article also addresses two important reasons. First of all, it argues that Germany has a novel legal framework, but also the government has invested an enormous amount of financial resources in order to support domestic prosecution, but also the investigation of international crimes at the domestic level. But after analyzing this article, I also asked myself a set of questions such as, to what extent and how can domestic court delivers effectively justice to victims of international crimes, and where the landmark court decision was simply perhaps the result of a legal framework or financial resources. And then I also asked myself if that was a too simplistic question in order to analyze the overall impact of the Koblenz decision, not only in terms of analyzing the contribution of Germany in the exercise of universal jurisdiction, but also its contribution in the development of international criminal law. And I argue in this paper, like, while these two factors are important, there were also additional factors that help us to understand why the Higher Regional Court in Germany was able to issue this landmark decision. And that's why I named this report The Road to Koblenz, because basically I'm analyzing a series of conditions that pave the way for the judges to be able to issue, again, this landmark opinion in Koblenz.
Let me summarize that just briefly. I mean, so I have a person in Syria working for Bashar al-Assad, committing a horrible crime. Now he's in Germany. And in Germany, this court is, taking a case on against him without any connection to Germany because of universal jurisdiction. And this is a first in recent years. I mean, we've had more than one decision by now, but this is really the game changer of this decision. Now, the conditions that you mentioned, I know you have 8 that you've listed in the study. I think we don't have enough time to go into details into all of them, but maybe you can just in one sentence sort of for all 8 or list them or kind of briefly introduce us to the 8 conditions that led to this decision of the Higher Regional Court of Koblenz.
Of course. Well, basically based on the research and again on extensive interviews and expert opinions, I was able to identify, like, in addition to the solid legal framework based on the adoption of the Code of Crimes Against International Law in Germany back in 2002, and also because of the great support in terms of financial resources invested by the German government, not only in the prosecutorial offices, but also in the judiciary. There were also another important element, such as the development of judicial precedents favoring accountability. And in this particular case, Philip, the Federal Court of Justice played an important role, for example, in dismantling all doctrines that basically required a legitimizing link between the crime committed abroad and Germany. But also the Koblenz case was possible because there was no functional immunity applicable to the defendants in the Koblenz cases. And that was also an important contribution rendered by the Federal Court of Justice. But another important element was also the implementation or incorporation of novel legal remedies by the Federal Prosecutor's Office in terms of implementing the so-called structural investigations and cumulative investigations. But also over the course of this research, I was able to identify the important contribution of international and regional cooperation that Germany has fostered, not only with other European states and European agencies, but also with UN mechanisms such as the International Impartial and Independent Mechanism for Syria. But in terms of the additional elements, of course, the role of civil society was crucial in order to launch the judiciary machinery and the prosecutorial machinery in order to put together these solid investigations in the country. But also I identified that an engaged media coverage was crucial in order for journalists to be able to communicate the outcome of those judicial decisions to civil society and for German citizens to be able to understand better why Germany was deciding these landmark cases at home. But finally, and perhaps one of the most important elements that I found was the importance of the independence of justice in Germany. Because as you may know, back in the 2023 World Justice Project, Rule of Law Index reveals that Germany is considered one of 5 countries that have the extraordinary conditions to uphold the rule of law and to hold fair and impartial tribunals, where Germany not only has been able to create the conditions for a safe forum for victims to seek redress, but also to respect the rights of the accused and to give the person a fair chance to defend him or herself in a court of justice in Germany.
Philip, if I may, I would just add why the situation in Syria, out of which those remarkable cases have arisen, is such a, so to speak, model case for the exercise of universal jurisdiction. So just to complete, so to speak,
wonderful.
The international legal landscape. Universal jurisdiction should not be exercised in the first place. Universal jurisdiction is a demanding kind of exercise because it is, in a simple word, distant justice because of the fact that there is no connection. But what was the situation in Syria? As Monica mentioned, we are talking here about crimes against humanity following an attack which is orchestrated, which follows a government policy. So it is the Syrian regime, the incumbent government, which is implicated in the crimes. And therefore, it would be naive to expect that criminal prosecutions take place there where they ideally should take place, on Syrian territory. And that's not an exceptional scenario. Very often, crimes under international law are crimes where the state itself is implicated, so that the most proximate jurisdiction is not available. Then one could look to available international criminal jurisdiction. Very fortunately, since 2002, we have, for the first time in international legal history, a permanent international court, the International Criminal Court, the ICC, which in principle is designed to deal with such crimes. But here, and I will not go into the details, for limitations in the ICC's jurisdiction, the court was not in a position to take up proceedings. And therefore, the only way, at least at this moment in time, as long as the implicated government is still in place, the only way to begin providing a measure of justice to the victims of those crimes is that certain states, wherever in the world, assume the subsidiary responsibility to act instead. And this is what Germany did, because, as Monica has mentioned, quite a number of Syrians were in Germany. So that was, so to speak, the facilitating element. And then all the structural elements that Monica has pointed out made it possible for Germany to take up those cases and to exercise universal jurisdiction in the end.
This too is a good bridge to my next question, because I think we need to be clear that this is an exception. So in Germany, you know, applying universal jurisdiction is an exception if we look at how this is, or how criminal cases go worldwide. You just mentioned the ICC. The ICC doesn't apply universal jurisdiction. In fact, as you can tell us from the history, it particularly excluded this possibility, even though it was suggested. I'd like to ask you, from the conditions that Monica has elaborated on in the study, in your own words, why Germany? How come in Germany now we have this exception? Why in Germany? Why the Higher Regional Court of Koblenz? Why did it apply universal jurisdiction? And maybe you can also tell us a little bit about the role of the federal court of justice and how it plays in here, which Monica also briefly mentioned.
Yes, again, very happy to do so. Perhaps to start with the International Criminal Court that you have mentioned, and just to add 2 sentences here on the jurisdictional scheme. The ICC can exercise universal jurisdiction, but only under very restrictive circumstances, only provided the UN Security Council decides to refer a situation to the ICC. In such circumstances, the ICC is, in fact, in a position to exercise universal jurisdiction. And as we know, this has already happened twice, in the case of Sudan, Darfur, and in the case of Libya. But, as we all know, and very regrettably, unfortunately, the Security Council, for political reasons, has become much less united in recent times, so that this option that the Security Council activates universal jurisdiction by the ICC becomes less and less a real option. And then, in the absence of a Security Council referral, you are absolutely right, Philip. Despite to what quite a considerable part, I would argue a majority of participants in the founding conference of the ICC would have desired, in the end, for reasons of political compromise, because some major powers were opposed to the idea, the jurisdictional scheme governing the ICC's exercise of jurisdiction is less wide than universal jurisdiction. And this is where Germany, so to speak, came into place. One should perhaps begin by saying the ICC was in general not established to substitute national jurisdictions, but it was based as a complementary jurisdiction. And the idea was that as many as possible national states, national jurisdictions, not just Germany, but hopefully states worldwide, would play their role, would, so to speak, add their share to the fight, to the struggle against impunity. And now Germany had, during the Rome Conference, had been one prominent supporter of the idea that the ICC should indeed exercise universal jurisdiction, in line with the idea that the ICC would exercise jurisdiction over crimes under international law. So it was very fitting, my delegation thought at the time, that the ICC would have a universal jurisdiction. So in that sense, when in the end, due to a political compromise, it became apparent that the ICC's jurisdiction was more limited, it could be seen as natural that Germany stood by its idea that international crimes deserve to come under the exercise of universal jurisdiction and would be prepared to contribute its share to close the jurisdictional gap that the ICC statute had left. And then perhaps, if you allow me to say this as a German citizen, I feel, of course, I cannot look into the minds of the German legislators, members of parliaments, but I have a vivid sense from my memory of the time that there was a widespread felt sense that it was proper for Germany not to take a leading role, but to make everything within its possibilities to contribute, to play its share, in view of the fact that at the darkest hours of German history, especially during the Second World War, under the German name, crimes so horrendous were committed that this eventually led to the breakthrough of international criminal law in its modern sense at the occasion, the historic occasion of the Nuremberg trials. And it was in this historic tradition, in this sense, in this feeling of a particular responsibility, not in the sense of legal responsibility, but moral responsibility, flowing from our dark past, that our members of parliaments, our political establishment decided, yes, let's make a bold step and enact a special statute, the code, the German Code of Crimes under international law, enabling the German judiciary to exercise universal jurisdiction as it is permissible under international law.
We've already spoken for quite some time. Time flies by when you're having fun. I have two final questions. So one for each of you. Klaus, I'd like to start with you. One final question for you. Going back to universal jurisdiction, according to German law, any district attorney that, sees or assumes that a crime has happened needs to investigate. Now, if we have universal jurisdiction in Germany, aren't our district attorneys overloaded with work because they just need to switch on the TV and because they can prosecute everyone according to this universal jurisdiction? They have to be active and will never get the work done. It's a little bit of a rhetorical question, but can you explain to us where the limits are and why universal jurisdiction might not be applied to every case?
Well, it has a bit of a rhetorical question, as you say, Philip, but it's also a very pertinent question, because it obviously makes common sense that what you allude to as a possible scenario would lead to nothing, would lead to a complete collapse of the system. So the first device that was built in the German legal architecture that Mónica describes so masterfully in her study was to concentrate the competence to exercise this power with one investigative body in Germany, and that's our federal prosecutor, situated in another beautiful German city called Karlsruhe. So it is only this institution which is capable under the law to institute proceedings under the Code of Crime. So if you like, the jurisdiction or the exercise of jurisdiction is monopolized. And this, I think, in retrospect, was quite a wise decision, because this has also allowed over time, and Mónica describes this in her study, to build up specific expertise. It is not an easy thing to exercise jurisdiction over international crimes. That's in many respects more demanding than ordinary crimes, and it is certainly special. So monopolizing jurisdiction at a certain place helps building up special expertise. So that's one thing. But even for the federal prosecutor, it would not be possible, unfortunately, and that's due to the number of crimes committed all over the globe. Unfortunately, it would just be overwhelming if in each and every instance where, as you say, he or she puts up the screen, investigations would have to commence. So the basic principle here is that, contrary to what applies usually in Germany, the principle is discretion, is prosecutorial discretion. The prosecutor is not required, wherever he or she gets aware of the possibility that a crime under international law has been committed, to start investigations. But prosecutorial discretion as a governing principle gives the prosecutor a choice or a possibility to make wise choices and to make use of the limited institutional possibility that also the German jurisdiction disposes of, to make a wise choice and not to get overwhelmed.
Mónica, one final question also to you. Looking forward, I want to ask you sort of about the impact that Koblenz, but also kind of the jurisprudence that we now have, will have. Looking forward, what do you think is the impact that the decision of Koblenz has nationally, but perhaps also globally, when we look at the enforcement of international criminal law and holding, perpetrators accountable? What's your opinion in that regard?
Well, I think this is a quite pertinent topic, Philip, considering the times that we are actually living, and again, the active role that Germany has played in the exercise of universal jurisdiction cases. And my hope with this study basically was to present the model that Germany has developed over the 90s in order for the justice system in the country to create appropriate conditions for future cases under the principle of universal jurisdiction. And what I'm also claiming in this report is, like, even though the German system of universal jurisdiction is far beyond of being a perfect model, it also helps as a guiding beacon for other jurisdictions to also rethink and perhaps analyze both the legal and institutional conditions for them to be able also to create these institutional and structural factors for countries to actually engage also in the exercise of universal jurisdiction and in the fight against impunity across the world. And perhaps that's the main contribution of Germany in this relevant topic, that while creating specific conditions and engaging with different justice sector authorities, international organizations, and being willing and flexible to dismantle certain doctrines that didn't help but constitute obstacles to the exercise of this important mechanism, I think that's also an important lesson for not only other higher criminal regional courts in Germany to implement similar strategies used by the higher regional court in Koblenz, but also as a model for international jurisdictions, again, to rethink the conditions, the institutional and legal conditions that they can implement and establish in their own legal frameworks in order for them to actually also join this important effort that Germany has been leading over the past years.
And of course, the first step is always to raise awareness, which you've done with this study, which again I want to congratulate you on. I really want to recommend that everyone reads it. But let me thank both of you so much for taking the time today and answering the questions, being a part of the discussion. Thank you, Professor Klaus Kress. Thank you, Dr. Mónica Castillejos-Aragón. Thank you both for being here with me.
A real pleasure, Philip. Thank you.
It was a pleasure, Philip. Thank you.